Hi, and welcome to Module 5 of the Training for High Fidelity Wraparound Providers Working in Wyoming's Juvenile Courts. Module 5 covers multidisciplinary team proceedings, which are also called MDTs. This is the fifth of 6 modules. If you haven't seen the others, please pull them up. Multidisciplinary teams and meetings are required by statute in dependency, neglect, CHINs, and delinquency cases. Wyoming statutes require that the court appoint an MDT within 10 days of the filing of a petition, and pursuant to the statutes, MDTs shall review the child's personal and family history, school, health, DFS records, and any other pertinent information for the purpose of making written recommendations to the juvenile court in child abuse and neglect, CHINs, and delinquency proceedings. The formation of an MDT is intended to ensure that all the circumstances impacting the child and family, especially those related to the potential strengths and needs, are fully identified and considered in formulating recommendations for the court. It is also important for you to know that MDT statutes set forth clear restrictions on the release of any information obtained through the MDT process. This information is confidential and cannot be used by anyone outside of the MDT process or for purposes unrelated to the MDT's function and authority. Confidential information can only be used for purposes related to making recommendations for appropriate family service planning and sanctioning of a child or family. This generally includes information relevant to the treatment needs of a specific child or family member, as well as information relevant to determining a child's placement, educational needs, and service needs. The members of the team may not use or share the information outside of the MDT meeting unless there is separate authority for gaining access to and using the information. Sharing information with people or agencies outside the MDT is a misdemeanor crime that can result in a fine of no more than $500 and no more than 6 months jail time, or both. If the child is placed outside of the home, the MDT is required to meet quarterly. In some jurisdictions, they meet more often. The statute is very clear about who has to be involved in MDTs and who may be ordered in addition to the mandatory members. The list on the left is the mandatory members of the MDT. So every MDT must include the child's parents or guardians, a representative at the school district, representative of the Department of Family Services, the child's psychiatrist, psychologist, or mental health professional, the county or district attorney or designee, the child's attorney and or their GAL, the CASA if there's one involved, and the foster parents. The list on the right includes the members that can be appointed by the court. They must be ordered as members of the MDT in order to be part of the process. This includes the child, a relative, a representative of the Wyoming Department of Health's Substance Abuse, Mental Health, or DD Division, other professionals or persons having particular knowledge of the family or child, which is where high fidelity wraparound providers fit in, and any other lay members. So just a reminder that in order to be part and attend the MDT, the high fidelity wraparound provider must be ordered as an additional member by the court. The MDT should also ensure the participation of the child to the maximum extent possible, and when direct participation of the child is not appropriate or possible, ensure that the child's voice is heard through other means. The child's or parent's attorneys will always have the responsibility for representing the legal interests of their client in the MDT process. The court oversees the MDT process, and this oversight includes giving appropriate professionals the authority to act when necessary and holding the members accountable for carrying out the court orders and delivering services consistent with a family service plan. The court relies on the MDT to advise it when determining when services and supports or sanctions it will order. All recommendations or concerns identified by the MDT should be brought to the court's attention as quickly as possible so that the judge can act upon the recommendations. The juvenile court judge has ultimate authority over the MDT process, but relies on the team to fully investigate and, whenever possible, agree on the best course of action to recommend, given the various needs such as education, treatment, and overall goals for the child and family. Members of the MDT do not have to come to a unanimous agreement. These are the roles and responsibilities of the mandatory members. Parents have to serve as an advocate for themselves and their children. School representatives inform the team of educational needs and concerns of the child and coordinate education services and transitions if appropriate. DFS caseworkers provide the history of the case, the current status, and any relevant information regarding services and supports, as well as reasonable efforts. The DFS probation officer supports the safety of the community, works with the delinquent, and advises MDT members on best practice and also reasonable efforts made. Mental health providers inform the MDT of identified and psychological and systematic concerns. The prosecutor represents the state of Wyoming's interest in the legal process. Remember, they do not represent the Department of Family Services in Wyoming. The guardian ad litem represents the child's best interests and their wishes in a hybrid model. CASA's role may vary depending on the court, but CASAs generally advocate for the best interest of the child. The foster parent or caretaker should be making well-informed recommendations and should be allowed to give input on major decisions, as well as update the MDT on the current status of the child. These are roles and responsibilities of other appointed members and invited attendees. There are two types of advocates that may be appointed or otherwise involved in the MDT process for children and families. These are direct and system advocates. Direct advocates may be appointed by the court to advocate, support, or help them navigate the child welfare and juvenile justice systems. Examples of direct advocates are family members, friends of the family, domestic violence advocates, and Uplift. System advocates assist in identifying the day-to-day issues faced by families in the child welfare and juvenile justice systems and developing solutions to address the system issues. Examples of system advocates include Prevent Child Abuse Wyoming, the Citizen Review Panel, Foster Parent Association, Uplift, Victim Witness Volunteers, and others. This includes high-fidelity wraparound providers as advocacy and support organizations. Direct advocates are invited by the family to be part of the MDT if so ordered by the court. Sometimes the Attorney General may appear at an MDT to represent the interests of the Department of Family Services. Also, the child or youth should be given the opportunity to explain their situation and progress if the child is age appropriate and mentally capable. A child's attorney in a CHINS or delinquency case advocates for the child's wishes while giving consideration for the child's best interest. A parent's attorney advocates for their client. The physician provides specific information about the child's health. And substance abuse treatment providers present an assessment of the youth's need for this type of treatment. Generally, MDTs are appointed at either the shelter care or initial hearing and make recommendations before the dispositional hearing, the review hearing, and the permanency hearing. An MDT must be appointed within 10 days of the filing of a petition. If a child's taken into temporary protective custody or detained by law enforcement, a petition must be filed with the court, and the shelter or detention care hearing must be held within 48 hours. When possible, immediate appointment of an MDT at this hearing is encouraged, and the MDT appointment order should provide clear expectations and a timeline. Other mechanisms, such as family partnership teams, court processing guidelines, and screening protocols, should be used to ensure that appropriate services are made available to families and children in juvenile court as quickly as possible. Since shelter care or detention hearings involve highly intrusive state actions, there's a compelling need to quickly develop a comprehensive understanding of the legal and clinical issues regarding the child and family. An MDT is an effective way to accomplish this. If possible, DFS should provide the judge and prosecutor with the names of recommended MDT members. When all the necessary requirements of an initial hearing can be met at the shelter or detention hearing, the two hearings may be combined as was discussed in prior modules. If an MDT was not appointed at the shelter care hearing, it must be appointed at the initial hearing. The adjudicatory hearing is, again, similar to a trial phase in other courts. The MDT is not involved in the adjudicatory hearing, except to provide recommendations for immediate detention and/or care and treatment of the youth pending formal adjudication and disposition of the court. The purpose of the dispositional hearing is to make a determination of what should happen to the child and family after the court determines or the parties admit that the allegations were true. The court must receive the predisposition report and consider MDT recommendations prior to entering a disposition. The hearing may not be held without the appointment and subsequent receipt of recommendations from the MDT. If a child is placed outside of the home, MDTs must meet at least quarterly. When a child remains in the home, it's still recommended that the MDT meet quarterly where possible, but there's no requirement on how often. After the petition is filed and an MDT is appointed, DFS or the prosecutor refers the matter to the MDT coordinator, who works with the family and the DFS caseworker or probation officer to schedule the first MDT meeting. MDTs are provided with the predisposition report prepared by DFS, the family service plan, the independent living or transition plan, the YES plan, if applicable, documentation for at-home placements, copies of evaluations and assessments, and an IEP, if applicable. DFS uses family-centered approach to identifying strengths and needs of every individual in the family. The caseworker may work with a family partnership to gather the necessary information needed to complete assessments and make appropriate referrals for further evaluation. The family partnership model is a cross-system method of working with children and families served by formal social services systems, such as child welfare, education, health and mental health, workforce services, corrections, and perhaps other systems. Family partnerships are comprised of support people identified by the family, as well as agency representatives who are involved with the family. The idea of the partnership is to provide a forum for the family to creatively develop strategies incorporating their natural supports with assistance from the systems in which they are involved. The facilitator works with the group to develop the family service plan for the family, providing clear expectations of the tasks and who is assigned to complete them. The family service plan can provide the MDT much of the necessary information to assist in making its recommendations. DFS also utilizes a family-centered assessment process that includes a series of assessments and screenings at various stages of intake to pinpoint specific areas of need. Through this process, a worker will be able to identify when a child or family requires further evaluation, make the appropriate referrals, and convey the results of the evaluations to the MDT to consider when developing their recommendation. The MDT may also identify areas of need, but members should only recommend additional evaluation or testing when other risk factors are identified after initial assessments and the information that would be gathered from the additional evaluations is necessary to make appropriate recommendations to the court. For example, the education member may feel that an education evaluation is necessary before making case planning recommendations concerning education. Common areas of screening, evaluation, or assessment are listed on the screen. Any plan for the child or family is to be made by the MDT team and the DFS caseworker. The MDT team then presents these recommendations for a plan to the court, and in formulating recommendations, they must give consideration per Wyoming statutes to the best interest of the child, the best interest of the family, and the most appropriate and least restrictive case planning options, and finally, the costs of care. The MDT report must be filed no later than 5 business days prior to the hearing. Again, MDTs are confidential, as well as the reports. And all records concerning reports and investigations of child abuse and neglect are confidential, pursuant to Wyoming Statute 14.3.214. Any person who violates this subsection is guilty of a misdemeanor and can be fined $500 or be imprisoned in jail for not more than 6 months or both. Recommendations for treatment should be made or supported by qualified individuals. The members should represent their particular profession and make recommendations consistent with their education, training, or certification. They should be measurable, and the DFS Family Service Plan should include the monitoring. When MDTs do not agree, the best practice is to work towards consensus unless it cannot be reached in a timely manner. Recommendations must address and balance 3 main areas: permanency, treatment, and education. A critical goal of this legal process is to maintain and repair family relationships and ensure that children are raised in their own family, provided safety can be assured. The MDT must begin with an understanding of the current family relationship in order to make recommendations about how it could be strengthened. Treatment recommendations should be made by professionals who have this training and expertise. It's DFS's policy to obtain assessments and evaluations from independent professionals who have no financial interest in the treatment recommendations. And the MDTs must work with schools to ensure that the educational goals of the student are fully addressed in the recommendations and that educational rights are not being compromised by the recommendations of the MDT. In delinquency cases, this should also include sanction recommendations. When a child is adjudicated as a delinquent, the MDT is given the additional responsibility to recommend sanctions to the court for consideration in the disposition. The Juvenile Justice Act provides detailed instructions on its purpose statement and statutes pertaining to sanction levels. The MDT report has to be filed with the court 5 days prior to the court hearing and should include at a minimum the following: case information, including specific and measurable goals or recommendations, including not limited to the name of the child, date of birth, names of parents, statement regarding parental participation, case initiation, type of action, meeting date, docket number, next hearing, presiding judge, current placement, permanency plan, list of all out-of-home placements, number of placements throughout the life of the child, Medicaid eligibility and enrollment status, verification of mental health screening that was done prior to any RTC or PRTF placement. Should also include the following key information that's listed on your screen. Finally, multidisciplinary team meetings should occur until a court's jurisdiction ends and the case is closed. Thank you for listening to Module 5. Please remember that this is one of 6 modules, and we hope you'll be able to view the remaining.